morning, Mr. Pretorius, and good morning, everybody.
Morning, Chair. Morning, Mr. McBride.
Morning.
Chair, just two matters before we commence with the evidence once more. The first is we have referred in evidence to two reports. The preliminary or first report from the IPID to the NPA, and the second or final report, both of which have been the matter of some controversy, particularly the differences between the two. The first report appears at page 191, that's the January 2014 report of the bundle, Exhibit Y.
That is Exhibit YA.
YA, yes. And the second one appears in the same bundle, or same exhibit, at page 227.
Thank you.
The second matter that requires mention, Chair, is on Friday I said that I would consult with the witness in order to determine at what level of detail it was necessary to continue and whether matters of general import and general principle could be dealt with in such a way as to exclude debates about the rights and wrongs of the many issues raised by the witness. On consideration, and because there is no fixed determination made clearly by yourself yet, Chair, nor by the legal team as to what actually occurred and why it occurred, and because of the need to hear all the evidence first and then only make an assessment as to why law enforcement agencies acted as they did, whether they were deliberately, actively, or passively part of any state capture project that you might find to exist. It's necessary to hear the detail first and not to cut out any of the detail so that all the facts are before you when you need to make a final assessment. There are various possible explanations for what occurred. But first, we have to show in detail what did occur. Because what is beyond doubt, Chair, is that the act or lack of action on the part of law enforcement over the past 10 years at least is central to the inquiry that you must make.
Yeah, no, that's fine. I think we have had a number of people, including some of the witnesses who have testified, saying that the law enforcement agencies had lost credibility and that they had no confidence in them. And that is why they didn't report or do certain things. And the nation might need to know whether there is a basis for that in regard to the law enforcement agencies, or whether those beliefs and perceptions really had no basis, because law enforcement agencies play such an important role in society. So we might have just, I think you are right to say, let's hear all the details. It might be quite a challenge, but it may be necessary if a credible determination has to be made at the end, one way or another.
Yes, Chair.
Yeah.
So all we know for the moment is that the evidence that has been given under the rubric of law enforcement agencies is critical to the terms of reference to understand what happened and why it happened and how it could be prevented from happening again. But in order to determine the precise nature of the role, without any preconceptions. We have to hear all the evidence in its detail, sadly, and you will bear with us in that regard, Chair.
Yeah, no, that's fine. It also, the role of law enforcement agencies, exactly what they did and what they didn't do, and to what extent they may have been influenced or affected by state capture, might also be relevant to the question of the levels of corruption that have happened where we are.
Yes.
Because if they are not acting the way they should act in regard to corruption, then corruption may have risen because of,
yes,
among other things, the fact that they were not acting, they were not seen to be acting, or people who were busy with acts of corruption knew that the law enforcement agencies were not going to enforce the laws.
Yes, that's precisely the point, and that is particular reference to 1.5 and 1.9, which direct the Chair to examine the nature and extent of corruption across a range of state-owned entities and at all levels of government.
Yeah, thank you.
Thank you, Chair. Mr. McBride, if we could go to paragraph 43 of your statement. It's on page 9 of Exhibit YA.
I have it, Chair.
We will deal with the Workmen's report as part of your evidence this morning in such detail as may be appropriate. But before we do that, you will recall at paragraph 36 of your statement, you raised the issue of the failure of communications between Workmen's on the one hand and yourself on the other.
That's correct.
I've been given 2 emails by the representative of Workmen's, I presume in response to those allegations and the allegations regarding the incorrect addresses which were used, as you state in paragraph 36. Chair, these will be handed up, copies will be made in due course, and they will be included in the bundles. Just by way of background, when did you physically leave the offices of IPID in 2015?
It was my last day was the 24th of March 2015.
Prior to that, any communication addressed to you at IPID would have been received had it been correctly addressed.
That's correct.
The communications you refer to in paragraph 36 of your statement, when would those have occurred? Or not occurred because the communications were never received by you because you say incorrect addresses were used?
This would have occurred before I was suspended, because after I was suspended I would not have had access to any documentation.
So the 2 emails that were handed to the legal team are dated respectively 13 April 2015 and 2 April 2015. Just for the record, would you look at them please and see if those are addressed correctly? subject to, of course, the next question, which is, were you there at all?
Thank you very much. Thanks, Chair. The one dated 13th of April is directed to the Acting Executive Director and Executive Assistant, and they are the correct email addresses. And the one dated 2nd of April is addressed to me, and it's a correct address, of course, but I am not there at this stage.
Yes, you were no longer there. But it is shortly after that you actually had an interview with Workmen's.
That's correct, Chair.
So the incorrect communications that you refer to in paragraph 36 would be relevant to the period before you left.
That's correct, Chair. It would have been helpful if copies of that email were sent by Workmen.
The second issue I'd like to deal with before we start again with your statement, you testified to a press statement made by yourself in conjunction with Mr. Pillay and Mr. Dramat.
That's correct, Chair.
Would you look at the document now being shown to you, please? Chair, I'll again hand up a copy to you. It will be included in the bundle.
That's fine.
We may deal with this at some stage, or we may just place it on record and deal with it in submissions, or you may be recalled at some stage to detail the analysis that is begun in this article. But in this article, I understand there is an analysis of the state of play within law enforcement agencies, the similarities in various fields of investigation or non-investigation, and an analysis of the possible causes and directions that the acts of NPA are taking.
That's correct, Chair.
Much of it you already mentioned in your evidence, but the question asked by the Chair, which I ask you now, is this a direct recording of your statement, or is it extracts including commentary by the reporter?
Chair, this is a verbatim statement that was released by the three of us. It's not commented on. It is just it's just published on this website.
Now, is this the one that we are talking about? I know that I've been given some document and the witness has been given some document. I don't know if it's the same document. Do we have the same document?
It's the same document, Chair, about which you raised questions earlier.
Yes.
It is there. It will be paginated and included in the bundle.
Okay, no, that's fine. Yeah.
But just to highlight some aspects of the article, on the first page of the article, the comment is made, the events at the Directorate for Priority Crime Investigation, DPCI or Hawks, IPID, the South African Revenue Service, Crime Intelligence and the SAPS, the State Security Agency, DENEL and the National Prosecuting Authority are not unrelated. There appears to be a remarkable coincidence in the methods used to remove officials from these institutions and the players involved and their intersecting interests. Do you stand by that view?
That's correct, yes.
It continues, in our view, attacks on individuals in these institutions are aimed at undermining the fight against corruption. A key part of all our mandates was to investigate cases of corruption. In reviewing our individual experiences over recent weeks, we have discovered a convergence in the cases that we were working on. Do you stand by that?
Yes, I stand by that, Chair.
A few lines on, well, let's just continue that paragraph before we get to the next. A common thread is that cases under investigation involved individuals or entities with questionable relationships to those in public office. Most of these cases involve state tenders of some kind that were awarded due to patronage with influential individuals in public office. Do you stand by that thesis?
Yes, that's correct.
The next paragraph reads, the manner in which officials were removed has followed a similar pattern. Internal documents or allegations from within institutions are leaked to selected journalists. Working in tandem with anonymous sources, facts are distorted in the media. Now, we dealt with that briefly last time you gave evidence on Friday, but I take it, and there has been and will be evidence that there were press releases in relation to the rogue unit relevant to SARS, in relation to the Cato Manor incident. Mr. Boyson will testify to that, and you've testified to the rendition saga. That's 3 examples.
Yes.
Is that correct? And then you state that it's uncertain how the leaks happen. Over the page, you say in paragraph 5, in all institutions cited here, the effective top leadership was removed and replaced. The replacements then institute far-reaching structural and operational changes in the institutions.
That's correct.
In the next paragraph, but 1, it continues, where matters have gone to court, the courts have consistently found in favor of the affected officials with cost orders against their institutions, only for them to be suspended again and investigated on a new slate of allegations. This was so in the matters of Robert McBride, Ivan Pillay, Peter Richer, Anwar Dramot, Shadrach Sabir, Johan Boyson, and Glynis Breitenbach, amongst others. And then towards the bottom of the page, the analysis continues. Corruption is the biggest threat to our constitutional democracy. This cancer has turned former comrades against each other. People who shared the same trenches in the fight for liberation are now at each other's throats for the sake of protecting corrupt activities. Is this statement one you stand by, and is it consistent with the analysis that the 3 of you engaged upon?
Yes, indeed, Chair. And I'd go further and say a lot of what happened in this period that we identified has continued and is still continuing.
Right. Now, of course, this is a high-level analysis that you, together with Mr. Pillay and Mr. Dramot, have embarked upon. It is something that the Commission is investigating and will only make its own conclusions at the conclusion of all the evidence that it is to hear. Insofar as your assistance may be required, with the assistance of any other of the witnesses, I take it you're quite happy to cooperate with the Commission.
Absolutely.
And we know that at the very least Mr. Dramot and Mr. Boyson, together with many others, are to give evidence in relation to the same theme of conclusions.
Yes, indeed, Chair, including my own colleagues, former colleagues from IPID, in particular Mr. Kuba and Mr. Sissoko.
Well, in the end, an analysis of various events that occurred and why they occurred the way they did and why they occurred at the time that they occurred, will be important, particularly in relation to the law enforcement sector. I don't know what I will make of this analysis at the end, but I am quite interested in the analysis that was made by people who were involved in the events in one way or another at the time. So Mr. Pretorius has said that you may have to be of assistance. I think that it will be important at some stage that as a witness who was party to the writing of this analysis, that I get the benefit of hearing how you saw things and you be questioned on your analysis and you are able to defend it if you want to defend it and engage in a discussion of how justified that analysis is, because I think it is quite important. Of course, as Mr. Pretorius says, there may be others who were party to writing it. The same would go for them. It would be important at some stage to look into those issues and give an opportunity to discuss the analysis and see how justified it was, and you all get a chance to, so to speak, defend it or promote it or advance it. So that at the end of the work of the Commission, it can be taken into account in the knowledge that it has been tested.
Thanks.
Yes. And in the meanwhile, we have to test the patience of the chair and the public out there and deal with the details. If we can refer then to your statement before Workmen's, and the statement is contained in one of the bundles. It's bundle B, I think. Exhibit YB, Chair. We had begun with your statement on Friday, and we were busy dealing with extracts from your statement before Workmen's. You raised a number of points which we have already traversed, Mr. McBride. And amongst those points was the propriety or lawfulness of the investigation as a whole. And you've told the Chair your views in that regard, some, if not all of which, were vindicated by the Constitutional Court judgment which later followed. But for the present, let's just deal with page 888 of YB.
Thank you, Chair Herbert.
You talked about his statement. Did you mean the interview?
Yes.
Okay.
My apologies, Chair. It was.
Okay.
This is a transcript of the interview, which it seems common cause is a correct transcript. Is that correct, Mr. McBride?
That's correct.
Up to page 888, as you've told the Chair, and just to place your further evidence in context, you've raised two issues. One was the issue about communications between yourself and Workmen's prior to your conducting this interview or agreeing to this interview with Workmen's. The second appears on page 888, where you say at line 8, then also the fact that a private law company is investigating a government investigative agency, albeit an independent one, before the NPA had made a decision. And then you expanded on that. Do you recall?
Yes.
You said, in essence, IPID is accountable to Parliament. It is a constitutionally independent organization, and disciplinary proceedings may not be initiated by the minister. And that principle is dictated by your constitutional independence. And your further issue that you raised was that this is not an official state agency of oversight making the investigation, but a private company.
That's correct.
Those were the issues you raised. If we can go then, please, to the judgment of the Constitutional Court to see how Acting Justice Bosiello came to his conclusions, and to give an overview of the conclusions he reached in the Constitutional Court judgment in regard to the independence of IPID and the powers of the minister. It's Bundle C, Chair, page 1301.
Thank you.
Exhibit YC, I should say.
What's the page number again?
1301.
1301.
Chair. It was a unanimous judgment of the Constitutional Court. The cover page is at page 1301. Don't intend to take the chair through the whole of the judgment, but to go to paragraph 8 on page 1309. Paragraph 8 reads, central to this well, perhaps we should just remind all concerned of the nature of the application. It was an application in which you were the sole applicant. Is that correct?
Yes, at that stage, but at the genesis, it was the organization and myself. This will become important, the distinction I make now.
Yes.
About it. So it was IPID and myself.
Right. And the respondents were the Minister of Police and the Minister for Public Service and Administration.
That's correct, yes.
Because it is not clear at all times what powers the Minister was relying on. Is that correct?
Yes, that's correct. And also that the Public Service and Administration regulates departments within the public service.
Right. And as friend of the court, amicus curiae, the Helen Suzman Foundation was also a party that made submissions.
That's correct.
It dealt with your challenge to your suspension. Is that correct?
That's correct.
Right. If we could go to paragraph 8 then. Paragraph 8 reads, central to this application is the crisp question whether, in the light of the applicable statutory framework, IPID enjoys adequate structural and operational independence, as envisaged by Section 206(6) of the Constitution, to ensure that it is effectively insulated from undue political interference. The background then is set out in paragraphs 9 and following. Paragraph 9 is summarized or summarizes some of the background. It reads, at the time when Mr. McBride took office on 3 March 2014, there was a political storm brewing over the alleged unlawful rendition of 4 Zimbabwean nationals in November 2010 and January 2011. Lieutenant General Anwar Dramat, then the head of the Directorate for Priority Crime Investigation, and Major General Sabir, then the provincial head of Gauteng, were allegedly implicated in these unlawful renditions. Correct?
Yes.
And you've stated that the investigations were first initiated under crime intelligence.
That is correct, yes.
Paragraph 10, IPID initiated an investigation into this matter overseen by Advocate Mo Singh of the National Prosecuting Authority, assisted by Mr. Innocent Kuba, the provincial head IPID Limpopo. On 22 January 2014, IPID issued its first report, the January report, which concluded that General Dramat and General Sabir were involved in the illegal renditions of the Zimbabweans. It recommended that criminal charges be brought against them. That is qualified by your evidence, which says that prior to the investigation by IPID, crime intelligence had conducted its investigation.
That's correct.
In paragraph 11...
I'm sorry. Actually, as I understood you, they kind of handed over to, crime intelligence handed over to IPID to say, continue.
Yes, Chair. I think for the purposes of the judgment and the constitutional challenge, the exact details were not brought before the court.
Yeah.
And hence, Judge Bosiello is raising the issues as is evident and in front of you.
No, that's fine. I think Mr. Pretorius and I were not asking because we were saying this is not accurate, but to say we have had the benefit of more details from you.
Thank you, Chair.
Yeah.
Paragraph 11 reads, Mr. Kuba explained in his affidavit that because he regarded the January report as provisional, he continued with his investigations. His investigations gave birth to a second report dated 18 March 2014, the March report, which was signed by Mr. Kuba, Mr. Matthew Sissoko, Chief Director, IPID Investigation and Information Management, and Mr. McBride. Contrary to the first report, the second report concluded that there was no evidence implicating General Dramat and General Sabir in the illegal renditions of the Zimbabweans. As a result, it recommended that no criminal charges be brought against them. This report was submitted to the National Director of Public Prosecutions for a decision on possible prosecution on 13 April 2015. Is that correct?
That's correct.
You have testified, in addition to the matters dealt with by the Constitutional Court, with the distinction between the report on the one hand and the statements contained in the docket or case files on the other. We don't need to traverse that again.
Yes.
Although the report, being the March or second report, differed from the first report, all the underlying evidence remained unchanged in the case file or docket.
That's correct.
Paragraph 12, faced with the glaring discrepancies in the two reports, the Minister suspected serious tampering. As a result, he commissioned Workmen's attorneys to investigate the two reports. Relying on the January report and the investigation by Workmen's, the Minister invoked his powers in terms of Section 6.6 of the IPID Act, the Public Service Act, and Chapter 7 of the Senior Management Services Handbook, and placed Mr. McBride on precautionary suspension on 24 March 2015. Acting on the strength of Section 6.6a of the IPID Act, read with the provisions governing disciplinary proceedings under the Public Service Act and the IPID regulations, the Minister served Mr. McBride with a notice to attend a disciplinary inquiry. And then reference is made to the High Court judgment and the findings made by the High Court, which to a greater or lesser extent were confirmed by the Constitutional Court. Paragraph 13 read, The Minister's action stung Mr. McBride into a defensive mode. Mr. McBride instituted an urgent application before the High Court, firstly for an interim interdict to restrain the Minister from suspending him, and secondly for an order declaring certain sections of the IPID Act, well, let me read directly, Section 63A and Section 66 of the IPID Act, Regulation 13 of the IPID Regulations, Section 16, capital A1, 16B, 17(1) and 2 of the Public Service Act, only insofar as they apply to the Executive Director of IPID. And I'm going to elide the quote a little. Certain paragraphs of the SMS handbook, declaring them constitutionally invalid and setting them aside. In addition, Mr. McBride sought an order to review and set aside the decision by the Minister to suspend him as the Executive Director of IPID and to institute disciplinary proceedings against him. The Minister then opposed the application. Paragraph 15, if we can skip at least one paragraph. The High Court found that the independence of IPID is expressly guaranteed and protected under 2066 of the Constitution, which is significant and decisive. That's a quote from the word significant and decisive is a quote from the High Court judgment. Furthermore, the High Court reasoned that given that IPID performs overlapping anti-corruption functions with the DPCI, that's the Hawks, it must be afforded at least the equivalent protections that the Constitution requires for DPCI. In Glenister, that's another judgment of the Constitutional Court, Glenister 2, this court found that the independence of the DPCI was an implicit constitutional requirement flowing from Section 2 of the Constitution and the threat to South Africa posed by endemic corruption.
I think Section 7.2, Mr. Pretorius.
I'm sorry, Chair.
I think you read Section 2 flowing from Section 2.
Did I? It's Section 7.2. I'm sorry, Chair.
Yeah, Section 7.2, yeah.
The High Court found that inasmuch as the DPCI is independent, despite there being no express constitutional entrenchment of its independence, by parity of reasoning, quote, the effect of the constitutional entrenchment of the independence of IPID is that the operational and structural independence of IPID must be at least as strongly protected as that of the DPCI. Do you see that?
Yes.
You've given evidence, Mr. McBride, of a range of incidents and occurrences which the legal team will consider, and your contention is that on several fronts the independence of IPID was interfered with, both in respect of investigations of IPID and in respect of proceedings instituted against yourself and other officers of IPID. Is that correct?
That's correct.
And that was the basis upon which you went to the Constitutional Court?
That's correct.
Specifically in this case in relation to disciplinary proceedings?
That's correct, against, in particular, myself.
And then paragraph 16 reads, the High Court went further to hold that IPID's constitutionally guaranteed independence requires more stringent protection. This is because, unlike the DPCI, which is situated within SABC, the South African Police Services, IPID is institutionally and functionally independent from SABC. And then at the end of paragraph 16, the Constitutional Court makes the following further comment on the High Court judgment. In this regard, the High Court held that IPID's oversight role over the DPCI would be compromised and might create room for political interference to seep through and render the DPCI's independence nugatory. It appears that the observation made by the High Court, quoted by or referred to by the Constitutional Court, was that the independence of IPID on the one hand and the Hawks on the other are interrelated, and functionally both need to be protected in order to guarantee the constitutional independence of each of them. Is that correct?
That's correct.
And then paragraph 17, crucially, the High Court held that the various sections of the various pieces of legislation I've referred to are inconsistent with section 2066 of the Constitution. In particular, and I quote once more, this was based on the fact that the impugned sections do not provide for parliamentary oversight in relation to the suspension, discipline, or removal of the executive director, and that they afford the minister unilateral powers and the sole discretion to terminate the executive director's tenure. Apart from the more general observations, that's the narrow issue considered by the Constitutional Court. Then, if we can move to paragraph 24, where the Constitutional Court made the following remarks. IPID is an independent police complaints body established in terms of section 2066 of the Constitution. Section 4.1 of the IPID Act requires it to function independently of the South African Police Services. This is to ensure that IPID is able to investigate cases or complaints against the police without any fear, favour or prejudice or undue external influence. Section 4.2 of the IPID Act requires that each organ of state assist the Directorate to maintain its impartiality and to perform its functions effectively. Importantly, Section 2 of the IPID Act requires IPID to play an oversight role over SAPS and municipal police services. Given the nature, scope and importance of the role played by police in preventing, combating and investigating crime, IPID's oversight role is of cardinal importance. This is aimed at ensuring accountability and transparency by SAPS and municipal police services in accordance with the principles of the Constitution.
Yes, Chair.
And your evidence, if it is to be summarized in a single concept, is that that independence was on a number of occasions testified to by you. It didn't occur.
That's correct, yes.
Then if we can go through to paragraph 39, please. The Constitutional Court remarks here, to subject the Executive Director of IPID, which the Constitution demands to be independent, to the laws governing the public service, to the extent that they empower the Minister to unilaterally interfere with the Executive Director's tenure, is subversive of IPID's institutional and functional independence, as it turns the Executive Director into a public servant subject to the political control of the Minister. Paragraph 40 and 41, which I intend also to read onto the record, expand upon this point. Paragraph 40 reads, without adequate independence, it would be easy for the Minister to usurp the power of the Executive Director under the guise of exercising political accountability or oversight over IPID in terms of section 2061 of the Constitution. In this case, acting unilaterally, the Minister invoked the provisions of section 16 capital A1 of the Public Service Act and placed Mr. McBride on suspension and instituted disciplinary proceedings against him. Undoubtedly, such conduct has the potential to expose IPID to constitutionally impermissible executive or political control. That action is not consonant with the notion of the operational autonomy of IPID as an institution. Put plainly, it is inconsistent with section 2066 of the Constitution. It follows that it is invalid and must be set aside. It may be, and we'll address this issue, and it may be rather an obvious conclusion to draw, that the Workmen's investigation, which we're dealing with at present, fell within the ambit of those suspension and disciplinary proceedings and should accordingly also be disregarded for the purposes of obeying the constitutional independence prescripts of the Constitution.
Absolutely.
And that was the point you raised.
That's correct.
Paragraph 41 reads, all this should be seen against the extensive powers IPID has to investigate the police. Section 28 of the IPID Act authorizes the Directorate to investigate a whole variety of matters. They are then mentioned, you've testified to those in your evidence. It continues further down, Section 28(1)(g) authorizes the Directorate to investigate corruption within the police, while Section 28(2) empowers the Directorate to investigate systemic corruption within the police force. There have in recent years been alleged instances of police brutality and killings perpetrated against civilians. Undoubtedly, these are very serious matters which affect the public. Naturally, the public has a direct interest in seeing these matters being vigorously pursued and properly investigated. IPID is given this responsibility. It is cast in the role of a watchdog over the police. It is therefore necessary to its credibility and the public confidence that it be not only independent, but that it must also be seen to be independent to undertake this daunting task without any interference, actual or perceived, by the Minister. Then if I may go finally to paragraph 43, Mr. McBride, it reads, to my mind, the cumulative effect of the impugned sections has the potential to diminish the confidence the public should have in IPID. As the amicus curiae emphasized in its submissions, both the independence and the appearance of an independent IPID are central to this matter. The manner in which the Minister dealt with Mr. McBride demonstrates without doubt how invasive the Minister's powers are. What exacerbates the situation is that he acted unilaterally. This destroys the very confidence which the public should have that IPID will be able, without undue political interference, to investigate complaints against the police fearlessly and without favour or bias. IPID must therefore not only be independent, but must be seen to be so. Without enjoying the confidence of the public, IPID will not be able to function effectively, as the public might be disinclined or reluctant to report their cases to it. The conclusion is based on the above exposition, and this is paragraph 44, I conclude that the impugned sections do not pass constitutional muster. It follows that the order of constitutional invalidity by the High Court must be confirmed. And then, as a result of that analysis, in paragraph 58, certain sections of the various statutory provisions or statutes were declared invalid. Paragraph 4 on page 1329 of Exhibit YC reads, it is declared that the decision of the Minister of Police to suspend Mr. Robert McBride from his position as Executive Director of the Independent Police Investigative Directorate is invalid and is set aside. And paragraph 6 reads, it is declared that the decision of the Minister of Police to institute the disciplinary inquiry against Mr. Robert McBride, which was to commence on 21 May 2015, is invalid and is set aside. That was the outcome of the judgment. So insofar as the disciplinary proceedings instituted as the consequence of a decision by the minister, the relevant minister, were set aside, that would inevitably cast a shadow over the part of the investigations leading up to your recommended dismissal conducted by Workmen at the instance of the minister.
Yes.
Is that your understanding of the matter?
That's correct.
If we can then return then to your statement, or rather the transcript of your interview before Workmen's. You say which is recorded that you say in the paragraph at the bottom of page 888, and we're back
Yes, I've got it.
On page 888 of the transcript, you recorded as having said, "On my appointment, I had asked for a briefing on all high-profile cases, including the matter of Sabia and Dramat, the rendition saga." Do you see that?
That's correct, yes.
You explained that to Mr. Worksman, to Worksman's, Mr. July, as you have already testified to the chair. Is that correct?
That's correct, Chair.
At the bottom of page 889, you, and because these are your words, perhaps you should place them on record. What did you tell Worksman concerning the investigation by crime intelligence? If you could just read the first few lines of the last paragraph on page 889 of Exhibit YB.
Okay. The second issue.
No, the first issue.
Okay. My issue in the briefing, and I can't remember the exact sequence of events, was firstly, crime intelligence was involved in the case from the beginning.
And the second issue you raised?
The second issue was that my predecessor, acting Ms. Mbeki, had told Kuba, Mr. Kuba, just report directly to me, don't report to, and
there's a word missing. What would that word be?
Sesoko.
Right. And then at line 5, you make certain further remarks.
So for me, already independence in the investigation was compromised the way it had been said. In other words, bypass the head of investigations. Those were my issues. Immediately, that was my concern.
So right at the outset, it appears you raised two issues before Worksman's. The one was the general complaint, really a constitutional issue as it turned out, yes, that the minister should initiate these proceedings against you, at least further to the extent of employing a private law firm, Worksman's, to conduct the investigation.
Thanks, Chair. And also, just to say, in the interview with Mr. July, I'm reporting on my first meeting with Mr. Kuba and the immediate concerns that I raised with him when being brought up to date with the circumstances in which this case arrived at IPID.
Right. So not only are you raising the, let's put it, the external concern that the minister had initiated this whole process, and yes, we've dealt with the Constitutional Court judgment in that respect, but also the receipt by you of issues that concerned you about the internal independence of the whole investigative process. Not only the fact that crime intelligence had conducted the investigation, as we know, into its own members, but secondly, that even within IPID, the independence of the investigation seemed to be compromised. All those issues were placed before Worksman's.
That's correct.
And what you're also saying to Worksman's, as I understand it, is that when you asked for your report, and you received the report on your assumption of office, these matters were related to you and they were of some concern to you about the propriety of the whole investigation that led to the issuing of what may be termed the first report. Am I correct? That's the remark you've just made.
Yes, that's my concerns about how the document reached, the docket reached IPID, how it was prepared by crime intelligence, and the involvement of crime intelligence and the exclusion of the national head of investigations and the sinister secrecy attached to what was expected of Mr. Kuba, which Mr. Kuba raised also with me initially, that he himself was concerned but was put under undue pressure.
Then you raised a further issue at the top of page 890. Would you place that on record, please, from line 2?
Yes. Then also that this is what I was told. Then also that
By Kuba.
Yes, that's right. Then also that he must work with the crime intelligence guy, and the crime intelligence guy also linked him up with Advocate Mosing. So for me already, independence in the investigation was compromised the way it had been said. In other words, bypass the head of investigations. Those were my issues immediately. That was my concern.
Continue then at line 10.
I was also concerned because it became apparent that crime intelligence operatives were involved in the arrest of the Zimbabweans themselves. They were also involved in the illegal repatriation. Those are my concerns. Then I questioned, because there were many people involved, who was involved at what stage in this crime that you mentioned to me, and to what extent. I also asked, what crime has been committed, by whom and who was involved in it? What are the elements of that crime? That's what it was. Basically, that's what it was.
Just before you go on, it appears, as we've already remarked to the chair, that crime intelligence were in effect investigating their own members. Had any of the members of crime intelligence been arrested?
They had been arrested prior to this incident,
By
and
whom?
some of those making statements which were brought to IPID had been arrested by General Sibia on a previous occasion when General Mdluli was appearing in court subsequent to having been arrested by General Sibia. General Sibia and his team then arrested some of the same crime intelligence people who were dressed in plain clothes and were putting the DPCI team under surveillance. And they were then approached by General Sibia and his team and were arrested on suspicion of about to commit a crime.
Right. So, against the background of what you were told by Mr. Kuba in relation to the independence in various respects of the whole investigation relating to the rendition saga, and your concerns about the independence of the IPID investigation and the propriety of the investigation, you then say to Worksmans, you decided to go back to square one, as we said last week, and deal with the essential elements of any crime that might have been committed. To do two things: one, to review the whole investigation to date,
yes,
arising from your concerns, and two, to complete the investigations by reference to further evidence, including an analysis of the cell phone data. Is that what you, in effect, told Worksmans?
Yes, I also indicated to them, I'm not sure where it is in the transcript, that I had asked that Sissoko be involved in all aspects of the supervision of the review and completion.
Then if you go to page 891, at line 4, what did you tell Worksmans there?
891, we were dealing with the General Piega matter, and on this matter of the Hawks rendition and crime intelligence, if my memory serves me correctly, there were some outstanding statements or warning statements at the stage when they spoke to me. If I'm not mistaken, it could be Sibia's warning statement.
And then against line 15, you were asked a question by Mr. July. What was that question?
He says, can I also clarify this? In that meeting, did Kuba indicate to you that on the 22nd of January, I submitted the report to the NPA?
And your answer?
I answer as follows, no, 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 no. What he did tell me was that he was in discussions with Advocate Mosing. No, he didn't tell me, and I don't think he would have. And I don't want to think on his behalf because the investigation was not complete, as there were outstanding statements. In fact, I think there was a statement from Jenny Irish Koboshiani in that thing. I can't remember the context of it.
Well, you don't have to go on because that's not entirely central to the questions that we need to deal with. At the bottom of page 892, you make a remark concerning your knowledge, at least at the time, about whether you would see each and every report, or whether the executive director would see each and every report that goes through to the NPA. Would you just explain the position then? And I'm referring to your statement at line 22.
Chair, if I can just go back to the previous one. I'm already expressing to Mr. July the absurdity of placing reliance on a preliminary report when there are still outstanding statements and other evidence to be included in a docket. In that 891, in the way I answered it, it's, that's why I'm actually giving him a long explanation. It was already obvious there that the fact that there was an existence of another report and that it was changed removed the basic common sense from all those who had been involved in it, in investigating this investigation. That actually everything that had taken place was lawful, and that the changes that were later made in the report did not affect the evidence in its totality in the docket. But there seemed to be an obsession with the existence, the mere existence of another previous preliminary report. It was, for me, and it blinded people from seeing that actually all of that was in order and that the additional evidence had to be put in. Basic issues, even myself, not as a lawyer, know that all evidence has to be considered in its totality. And other people who are lawyers were just missing it.
Right. What is the position with reports? Is it true that on occasion provincial heads in IPID would send reports directly to the NPA without them going past you?
Yeah, Chair, often they wouldn't even reach Mr. Kuba because the provincial heads within the province are appointed there precisely to engage with the NPA on completion of investigations, and the regulations and the SOPs, I can't remember.
Standard operating procedures.
Yeah, which one specifically deals with this, but provincial heads must then submit to the NPA.
But how does that then gel with the statutory requirements that the executive director must sign reports? It seems that there's a mismatch there.
Yeah, the issue relates to when it's an investigation driven from the national office, then the appropriate person to send it to the NPA would be me in terms of the regulations and part of the Act, and if it involves more than one province, as was the situation in this case.
I must say I didn't, when we dealt with the statutory requirements, didn't understand the statute to make that distinction between provincial and national reports. It seemed to be a blanket provision that all reports to the NPA, and I presume that means final decisive reports, must go through the Executive Director. That's as I read the statute. But perhaps I'm wrong, and perhaps you can correct me.
Yeah, the issue says the provincial head or the Executive Director, as the case may be. That's the legislation in the Act.
Section 4. I'll just check with Section 4.
Regulation 5, yeah. It mentions both.
All right, we'll just check that. Then on page 893, you deal with further material before Workmen's in regard to your knowledge of what reports, provisional or otherwise, had gone through to the NPA. And at line 5...
I'm sorry, Mr. Pretorius, I don't know whether maybe it might be worthwhile just mentioning what the statute says in regard to that issue, because at least section 7, subsection 4, to the extent that that is the provision we are talking about, doesn't also refer to a report. It simply says the Executive Director must refer criminal offences revealed as a result of an investigation to the National Prosecuting Authority for criminal prosecution and notify the Minister of such a referral. Would that be the provision that we are talking about when we talk about the requirement that the Executive Director is the one who must refer matters to the NPA?
Chair, indeed, is that provision that's within the Act and the relevant regulation and the standard operating procedure read together. So there's a specific one dealing with that.
Including reports, talking about reports, for example, in terms of the regulations, or that's where a reference to reports might be.
That's correct, Chair. On my first day of testimony, we covered it.
Yes.
And I read it out, that provision which deals with...
Okay.
Yes.
Okay.
And also to understand the practicality of every report
having to come
through the Executive Director, it will be a bottleneck. And hence, that's why the provinces deal with the relevant DPP.
Yes. How many reports approximately per year would the IPID transfer to the NPA?
It would be thousands, Chair. It would be thousands.
All right. But the overall duty to refer or to ensure that referral takes place, I suppose possible to read into 7.4, is that of the Executive Director.
Yes, correct. In fact, if I can just clarify, the Werksman's report, for whatever it's worth, extracts that particular provision that I think it's Regulation 3, subsection 5I, in the report, which deals with this aspect.
Okay.
Yeah, so we dealt with it on my first day of testimony.
Okay.
And the regulations, these are the regulations, which appear at page 62, talk of the investigation of criminal matters. That's 62 of Exhibit YH. The investigation must be done in accordance with Regulation 5. The Executive Director or the relevant provincial head must designate an inspector, and then Regulation 4E reads, if the executive director or relevant provincial head, as the case may be, determines that a full investigation is warranted, the investigator must, as soon as is practicable, but within 24 hours after determination, and I go to E, after collecting all evidence, statements, technical and expert reports, and I stress after collecting all evidence, statements, technical and expert reports if applicable, submit a final report on the investigation to the executive director or the relevant provincial head, as the case may be, containing recommendations regarding further action, which may include disciplinary measures or criminal prosecution of a member. So it appears that as far as the regulations are concerned, the provincial head may act in addition to the executive director being obliged to submit referrals in terms of the legislation.
And that would be specifically with offences committed within that specific province. It's not clarified like that, but it's taken, that's the purpose of the provincial head.
In any event, quite separately from that, you were making 2 points to Workmen's. In fact, in accordance with your evidence, more, but the 2 principal points for the moment were that you weren't aware of an original or provisional report.
At that stage.
Yes.
Yes.
You became aware later.
Yes.
The second point you make is that at the time you received your report from Cuba in January of 2014, you were satisfied that the investigation was not complete. You ordered a review in the procurement of further evidence.
Yeah, that was in March, upon my arrival, March 2014.
Sorry, March 2014.
Yes.
That was when the report was made, my error. Then in the first paragraph on page 893, from line 5, what did you say to Workmen's?
So I'm doing this interview with Workmen in 2015, 17th of April, and I say to them at this stage, what I know is there is one report I have seen, which I have signed. The only issue on that report was that it was badly written. There were spelling errors, grammar, and stuff like that. There were no other issues.
And then the question put to you at line 14, what was that question?
This is Mr. July.
Yes.
Let's make this supposition. If you knew about the existence of the report which had been given to the NPA, would you have asked for that report which had gone to the NPA? My response, well, the investigation was not completed. That was my impression. If you recall from the papers, we had briefed Minister Mthethwa on the status of various of these high-profile cases. It was just a status report, and it was soon afterwards. I think I indicated that in that report that these cases were in the process of being finalized. It's in that information note that you will see. Just as my memory serves me now, as you ask me questions, I am being reminded. Therefore, the investigation was not complete because in the info note, I mentioned that the investigations were in the process of being completed.
Then, again, you are asked a question at line 7. What was that? Of page 894.
Okay, Mr. July. If Kuba says the investigation was completed, but there was new evidence that came up, would he be right in that?
Aside from the logic in that question, just continue.
Yeah, he said, and he quotes Kuba now, I had completed the investigation, but there was this new evidence about the cell phone cell phones in relation to Sibia, which needed to be tightened up.
And then your answer?
Chair, he's actually contradicting himself in his question, because he's saying, Kuba says the investigation is complete, but there's other evidence that needs to be dealt with. And therefore, whatever Kuba said, whatever Mr. July says Kuba says, the investigation cannot be complete if there's still additional evidence to add to it. It's just illogical. I'm not sure why such a stark contradiction is not picked up.
Yes, it says what it says. And in the first sentence, Workmen say to you, Kuba says the investigation is complete, but there's new evidence. The investigation is complete, but I've got to investigate further matters. We'll see what Kuba said in due course, and if necessary, hear Mr. Kuba. But the logic is open,
Chair,
at least on the face of it, to question.
It's painful to look at this, because the more I go back to it, I see it was quite obvious, even to Mr. July. It should have been that actually what they were on about was a non-event. Why they still persisted becomes stranger and stranger as I go back through this transcript.
Is it possible to look at it this way, that Mr. Kuba, when he submitted the first report, regarded the investigation as complete at that stage, and that whatever new evidence came up later, which might, strictly speaking, have meant that once there was new evidence, it should thereafter no longer have been regarded as complete. But from his point of view, prior to new evidence coming up, is it possible that that's what they are talking about? You know this situation much better than I do, because you have looked at all of these things and dealt with them.
Chair, in my engagements with Kuba, initially on the first day and subsequently,
yes,
and even until recently, he has never on one occasion told me that that January report was a completed report. He also has indicated to me that he made this known to Mr. Mosing.
yes.
But one has to place it in the context of being pressured by Ntlemeza and by Mosing. And even though indicating to Mosing it hasn't been signed by my executive director, Mosing insisted that it comes to him. So that has been Kuba's position for ever since the first day.
Yes.
Yes.
So what Mr. July was telling you, I think he started by saying suppose, I'm not sure whether that's, but to the extent that he was telling you that Mr. Kuba's version was that that first report, the investigation and that first report was final and that investigation was complete, to the extent that that's what he was saying Mr. Kuba told him, that was news to you. You had not heard that from Kuba or anybody before.
Yeah. Chair, not only was it news to me, I had not heard that. I immediately became suspicious because I had never been told that. And at last came across this strategy of, but they said this, and if they said this, which would be to put a falsity to you. I last came across this while I was being detained and tortured under Section 29 in 1986, is to force a confession out of you on a false supposition which is then put to you. So that's what it reminded me of, and my suspicion became heightened by why say something to me, and subsequently a number of issues which Mr. July put to me about that Mr. Kuba said Kuba actually, in his various statements, subsequently says he didn't say, and actually draws our attention to aspects in his interview with Mr. July where he says things which are opposite to which Mr. July put as purporting to come from Mr. Kuba to us. So that was a major concern during the interview, and it's...
Okay, thank you.
You, just for reference purposes, Chair, you deal with this at page 1018 in one of your affidavits, where you say in the court application to which we've referred at paragraph 32, to avoid overburdening the papers in this matter, I do not attach copies of the full transcripts of the interviews conducted by Workmen with Kuba, Sissoko and Mo Singh. I attach only the pages that I refer to in this affidavit, and then you offer to provide the full transcript to the court. But then in paragraph 33, you say, in the light of the facts attested to by Kuba and Sissoko, and regardless of what Mo Singh, Mo Kangwe or Kuba may have believed at the time, it is clear that the January 2014 report was not a final report. This is because, and you talk about the outstanding evidence, warning statements, and other matters, including compliance with the regulations. Those are all summarized there. We've referred to them, I think, in evidence. But what I want to do is go to page 1020 of this same affidavit, and that 1020 is in bundle
C.
I think Mr. McBride says Exhibit YC.
YC, correct, Chair. Paragraph 34.
What's the page again?
One
1220.
No, 1020, Chair.
1020. Okay, thank you. Yes.
Reference is made to what Mo Singh said in his interview with Workmen's, but can you recall from your own memory of reading the transcripts? We're going to check the transcripts now, and there may be a discrepancy between what is said here and what Mr. Mo Singh said, and we're checking that, and we'll deal with it after the tea adjournment. But you say in paragraph 34 here of the affidavit, Mo Singh explained in his interview with Workmen that he wrote the word draft on the January report on receiving it from Kuba because the report was not complete, and you attached the relevant pages of the transcript as RJM3. Do you recall anything about that?
Yeah, I remember that.
Was it not an earlier October report that Mo Singh was referring to?
I think the issue here is the January report at all times for the query. And it is that report, so Mo Singh advances this, he volunteers it, that he wrote draft on it. Why he advances it, I'm not sure. The moment you write draft on anything, that means it cannot be a final report, whatever it is, whatever creative explanation he gives. He volunteers. I'm not sure, he should answer why he volunteered it, but he wrote draft on the report. And he then goes on to explain why he wrote draft in a quite a creative way. But in any event, even from his explanation, from memory on that interview, he is dealing with additional evidence or statements. Once he understates them in his explanation, he does give an explanation that something is outstanding.
In any event,
I'm sorry, Mr. Pretorius. Ms. McBride, you are emphasizing the status of that first report quite a lot. And I just want you to confirm that you emphasize its status as having been a preliminary report or not a final report, or the investigation relating to it not having been completed, because the part of the point you make is that the moment it's accepted that that report was not final, the moment it's accepted that that investigation was not complete, this whole thing about the charging of people falls away and should have fallen away. The problem is why it was not recognized that that investigation was not complete and that that report was a preliminary report. That's part of the point you make.
Yeah, Chair, that is part of the point. The second point would be, and this is hypothesis, assuming it was regarded by some people, and I make it in this affidavit, as completed, the fact that there was additional evidence which was not factored in the first one, and that the changes that were made to the report and not the evidence in the docket were lawful and were proper and were necessary, also escapes all this range of lawyers in the process. If you take the factors perhaps in an isolated fashion, each of the reasons that we are speaking about, one could come to some reasonable but not acceptable explanation. If you put the sequence of events together, for me, in my opinion, there is a determination to find guilt or to find scapegoats so that you can deal with your original aspect of getting rid of Dramat. So ultimately, that's the plan. Whether everybody downstream knew exactly what the higher level plan was, it's up to them to explain. And I think it would be helpful if they do explain. But if you take all these different aspects into account and the sequence of events and the failure for proper common sense to kick in with legally trained minds, for me it's problematic. It's difficult to find, to even understand perhaps an unacceptable explanation.
Thank you.
yes, perhaps it is correct, Mr. McBride, that we are focusing too much on the extent to which other people focus too much on the word draft or provisional or final. The truth of the matter is, you raised, when you were briefed in March 2014, serious questions about the independence of the IPID report that was then in existence, or the investigation rather, that was then being conducted. You say you weren't aware of a formal report. But notwithstanding the existence of a formal report, rather, you had concerns, which you've raised now, which we've dealt with from time to time in your evidence.
That's correct.
And those were serious concerns about the independence of the investigation and the manner in which it was conducted. You therefore ordered a review of the investigation and the finalization of the investigation in regard to warning statements and in regard to cell phone record analysis. Correct?
That's correct, Chair.
You then signed a report that took account of the further investigations directed under your command. Is that correct?
That's correct.
And then you submitted that. So it seems that it's at least arguable that whatever the status of the so-called first report or provisional report, by whomever it was signed and whatever its purpose, all, including Advocate Mo Singh, knew that there was further work to be done.
Absolutely.
And whatever opinion was recorded in the various reports, it is still incumbent upon the prosecutor to make his or her own decision, not on the basis of IPID's opinion, but on the basis of the original evidence in the report.
Absolutely.
Or in the file. And that was never interfered with.
In fact, to go further, Chair, is that all statements, including the dodgy statements, as I refer to them, that could not be substantiated, were included in the docket. So all evidence, incriminatory and also the exculpatory evidence. So all was there, and a prosecutor applying their mind could have come to a decision based on what was there. None of that was altered.
And would have been obliged to come to an independent conclusion.
Absolutely.
Given the responsibilities of a prosecuting authority.
That's correct.
All right.
Did anybody ever say to you, including Mr. July, or challenge or question your right to ask Mr. Kuba to do further investigations when you asked him after your appointment as Executive Director? Did anybody ever question whether there was anything wrong in you saying to Mr. Kuba, just do further investigations here? As you understood them.
Chair, nobody questioned my right, but nobody in all this process reflected on it. That would be a normal, common sense thing to do. To get an update on what are the key investigations this independent investigative directorate is busy with. It's logical. Somewhere along the lines in the tone or whatever, there was some dissatisfaction and a reading in, at least in their minds, and which I interpreted as that Kuba was called to my office, almost as if it was as if me coming in, I summons people to my office. And it was not right for a number of reasons, including the fact that Mr. Sissoko had Mr. Kuba's number. I didn't even have Mr. Kuba's phone number. And I arranged for Mr. Kuba to come to the office via Mr. Sissoko. So that's what happened. But there was this notion of, Kuba says he was called to the office, but the tone from memory was, he was this new guy just ordering people about.
You see, it would have been important, it seems, that at least Workmen's, Mr. July, they look at that question whether you were entitled to ask Mr. Kuba to do further investigations, because if one accepted that you did have that right and Mr. Kuba did further investigations, whatever he got out of that further investigation, whether it was against General Dramat or in his favor in terms of prosecution, had to be taken into account. In this case, you say it happened to be in his favor. And if it was in his favor, it had to be taken into account as well. And I imagine that there is an argument to say, to the extent that Mr. Kuba may, in his earlier report, have reached a conclusion that was inconsistent with the outcome of the further investigation, he may well have been entitled to say, well, I can't maintain that position in the light of what I've found out now.
Yes.
So the question is, if the minds were directed to these issues, maybe certain conclusions wouldn't have been reached. And the question is, I think from what you say is why they escaped, these issues escaped people.
So, thanks, Chair. I want to add something else. There was, and I even feel uncomfortable to say it now, there was this notion that myself and Ramat are from the same background. Therefore, I felt a sense in me to want to help him, whatever the circumstances or merits of the investigation. Where that sense or allegation came from, I don't know. When I said to them, I myself, I don't know Ramat. Ramat was on Robben Island. He was in prison with my father. I then found, later read in a newspaper, as like innuendo, yeah. In fact, McBride's father and Ramat were together on Robben Island. And that's how it was said. So every time you said something to show that, actually bear this in mind, whatever you're thinking, the way you put it, that I actually personally don't know General Ramat. And I think I make the point in the interview, I met him when I was, for the first time, at IPID, and in engaging with him as an official in a assisted department. That is then taken and misconstrued and fed to journalists as if it's still a sin and an offense to have been part of the liberation struggle. So there was this, I don't know if it was the only way to say it, and I say it on days when I'm not so irritated about it. I say it's like some people got struggle envy. I can't help it if people are not born at different stages. I mean, I cannot have Rivonia envy. I was not born yet with former President Mandela and him decided to embark on that. For me, I revered them. They gave us light. But for me to start having resentments about them is a foolishness and a sense of inadequacy that I cannot understand.
Thank you. Mr. Pretorius.
Chair, is this a convenient time? And may I ask that, because I need to traverse a particular issue that has now emerged as to what Advocate Mo Singh might have said about the earlier report being a draft report, I just need to check something with the witness, if I may, in relation to transcripts in the bundle. I don't want to spend too much time on the detail of the label attached
if you can
to the
avoid
first
it.
and second reports. What is clear is that further investigation needed to be done. And if it hadn't been done, there would have been a serious problem laid at Mr. McBride's door. But I do want to just place one piece of evidence in this regard before you and then move on.
Yes. Are you asking for
The
a
short
longer tea break?
Say 20 minutes or 25 minutes.
25 minutes altogether?
Yes, please.
Okay, all right. That will take us to 22:12.
Yes.
We'll adjourn until 22:12.
Thank you, Chair.
We adjourn.
you, Chair. Let's go to page 894, please.
Thanks, Chair.
Of Exhibit YB. This is a continuation of the transcript of your interview with Workmen. At page 894, line 14, you say what further investigation or work needed to be done. That was a new analysis or an analysis of cell phone records. Was it an analysis or a new analysis of cell phone records?
In essence, to make the distinction, it was specifically an analysis related to towers. As to the...
But an analysis had to be done. I don't want to go into too much detail. And additional statements and warning statements, you say?
That's correct.
I think the emphasis behind Mr. Pretoria's earlier question may have been to seek to establish whether what was new was an analysis of information that had been in existence already, or whether it was new information with new analysis.
Chair, it was, if I can put it this way, as far as I am aware, there wasn't any information related to cell phone analysis yet in the docket.
Yes.
But that some cell phone analysis was done, but it involved as to who called who.
Okay.
But the issue relating to the towers,
yes,
that is, where was this phone on a particular day,
yes,
or on a particular set of dates,
yes,
had not been done. It now had been obtained and needed to be.
Okay. Thank you.
Then on page 896, you are asked, I just want to clarify this point. At one stage you gave the docket to the Minister and you say yes, 14 April 2014. Is that correct?
Yeah, during the interview I might have got the actual date wrong. We are still awaiting the date of confirmation when the...
Well, you say 14 April 2014, the date it was signed. Is that the docket?
Yes, that's correct.
And you say later down the page that it was in November of 2014 that it was given.
That was given to the Minister,
yes. And then over the page, you say at line 10, that's page 897, of Exhibit YB, that of course later on it became clear that the Minister disagreed with your report and that the Minister said as much in Parliament, and we know said as much to IPID itself in March 2015.
That's correct.
And it was in Parliament that you told the Chair earlier last week that you approached the Minister and said that he'd made a mistake and there was a way to de-escalate the issue.
Not in Parliament, it was at the stadium on
at the stadium in Cape Town.
January 8th rally, yes.
Yeah. All right, whatever Mr. Kuba or Mr. Mo Singh, Advocate Mo Singh might have said to Workmen's, we'll deal with separately. They can account for what they said. But your evidence is, or your interview with Workmen's is summarized at page 900, line 3 to 5. Where you say, all I know is there's one report with one set of dockets which I signed, there's only one report I know. You see that? Page 900, line 3 to 5. You
Yes,
see
I have that.
That's what you said to
Yes,
Workmen. Is that
That's
correct?
correct, yes.
Is that correct?
That's correct.
And then at the bottom of the page, it's put to you, what you are saying you had with you at the time was an inclusive report. You then say, no, I'm not saying that, Mr. July, please let's be honest with each other. I didn't say that. I said I got the one final report, or I said I got one final report which I signed. I didn't say it was an inclusive report.
Inconclusive, eh?
I didn't say it was an inconclusive report.
Yeah, that's correct.
So let me just repeat, I may have got it wrong or not been clear. It's put to you at the bottom of page 900. What you are saying you had with you at the time was an inconclusive report, and you say, no, I'm not saying that. You got one final report which you signed. I didn't say it was an inconclusive report. There seems to be a possibility of confusion there about final or inconclusive reports and between the first and the second report.
I'm not sure why Mr. July was confused at that stage and why he put it to me that I had spoke about an inconclusive report that I had signed. It doesn't fit in context.
And then, if we can go to page 904, please. On several occasions during this interview, you make it clear that you were aware at the time of a single report, which was, in your view, the final report which you signed, which contained the additional investigative results which you had directed. That you repeat several times. But on page 904, line 10, you say, in relation to a question from Mr. July, which reads as follows at line 4 on page 904, in the same breath then, we can't ask you about the inconsistencies that exist between the two because you don't know anything about that.
Chair, if I can just come in, that is very critical about the confusion of time and its passage. Because what I had indicated earlier is that in March, on arrival in IPID, I didn't know about the report. A year later, Mr. July suggests to me, well, then a year later, after everything and after signing the final report, you can't speak about inconsistencies between the two reports. Whereas a year later, I would have seen all relevant reports relating to the subject, but I think his question there is basically expresses his confusion with the passage of time, which I made a point on I think Friday, that one must be conscious of the passage of time and different things happen at different stages.
Well, as at the time of the interview, 17 April 2015, you do say at line 10 on page 904, I don't even think there are inconsistencies. There is additional evidence. One report is longer than the other. One report has additional information to the other one. One report has an analysis of cell phone records and it has warning statements, which is a normal thing. So I wouldn't say inconsistencies. I would maybe say a change of analysis. I know in one case they had to send a statement to be analyzed to say whether the guy was truthful or not, because of evidence which came out from a cell phone, and it goes on. Yeah. At the bottom of the page, 904, then they had to look at other people's statements again and analyze, it should read, them. It is correct that aside from the additions or further evidence, the final report which you signed differed from the first report in that witness statements were quoted in the second report, and those quotations differed from the quotes in the first report. Am I correct?
That's correct, yes.
Those are fully analysed in the Worksman's report in a spreadsheet. You're
That's
aware
correct,
of that?
Yes.
The statements themselves, you've repeatedly said, remained in their original form.
That's correct.
It was an analysis of the statements contained in reports.
Exactly, and particularly what was the evidentiary value against the background of the new evidence. So what had been said initially no reliance could be placed upon it.
So were certain quotations in the first report omitted from the second report?
Yes, that's correct.
What was the reason for that?
According to Kuba, they were of no evidentiary value.
Right. And we'll see what Kuba says about that.
Yes. And even now, if you read what was removed, it's of no evidentiary value in terms of the...
Can you give one example to illustrate the point? I'm not going to go into a full analysis of all the transcripts, and
I think in one
we've made the general points about the report.
Yeah, in one statement, someone reports about someone going to a liquor store to buy some liquor. In this scheme of things, it's kind of irrelevant, so Kuba leaves it out and adds more relevant stuff. So in terms of just stating from the original statements, taking large chunks of quotations, in the second statement, he's more particular about what the value is, and stuff that sort of pads up the report with no evidentiary values removed.
We can put away that bundle for the moment then.
Before you do that, can I just establish was it ever established who had made the alterations on that first report? Or you don't know?
No, it's established. Mr.
Yeah.
Kuba said he had made the necessary changes based on new evidence. So it was never in doubt that Mr. Kuba said he had worked with Mr. Sissoko.
Yes.
On Mr. Sissoko's...
Not Mr. Sissoko. Mr. Sissoko? I thought he had been given instructions not to
in
give him the report. In the first one, I'm talking about the first one. The one that was said to have been altered.
I'm not aware of that. That the first one...
No, okay, let me repeat. Maybe I've confused you.
Yeah.
You know, when we talk about alterations to a report, to the report here, as I understand it, that's a reference to what we have referred to as the first report or preliminary report. Now, that's the report that had been done by Mr. Kuba.
Yes.
Before you were appointed executive director.
Yes.
So I seem to get at some stage when I read some of the documents that it seemed to be unclear as to who may have effected certain alterations on that first report. So my question was whether, as far as you know, it was ever established as to who had effected those alterations.
I think it's common cause between Mr. Kuba and Mr. Mosing.
Yes.
That they would send the reports of those preliminary reports to each other. And on occasion, Advocate Mosing would send it back to Kuba again with some alterations or whatever the issue was at that stage. But it's not in dispute that that was taking place and that there was...
No, I understand that because you did say that, I think, last week, insofar as one talks at a general level.
Yes.
I'm just talking about the specific alterations that Workmen and the minister were talking about, which were formed the basis of you being charged to say certain alterations were made. They were made with a certain motive or intention or whatever. So those specific alterations, those are the ones I'm talking about. Whether it was established whether Mr. Kuba had made them or Mr. Mosing, or was it in dispute as to who had effected them, as far as you know?
Thanks, Chair. If I'm understanding you correctly, it would be, and to respond, it would be the report that was done after the review and the addition of the new evidence is the second report, which Mr. Kuba then changed the emphasis of analysis on the report under the supervision of Mr. Sissoko, and they had worked on Mr. Sissoko's computer.
Oh, okay.
Yeah.
Okay. So, but the actual alteration was said to be on which report?
Well, in essence, the first report, preliminary report, was changed by Mr. Kuba.
Yes.
To accompany the docket.
Yes.
Yeah.
Yes. So it was the first report.
That was changed, yes.
Yeah, but it was changed after there was the final report.
The final report effectively changed that preliminary report.
Yes. Okay, thank you.
In that regard, perhaps we could go to page 1237 of Exhibit YC. This is a statement by Kuba on affidavit in the litigation to which you've referred.
I have a check.
Paragraph 21 reads, after Sissoko and I were tasked by McBride with finalizing the report, I would visit the Pretoria office from Limpopo whenever I could. I would sit at Sissoko's computer to make changes to the draft as we discussed them. Sissoko and I re-evaluated all the evidence and debated what findings could reliably and sustainably be made on the evidence. I would then effect the changes to the report on Sissoko's computer. Paragraph 22, Sissoko's input was important because he has a prosecutorial background, so has a good understanding of what findings a prosecutor would accept as sustainable. He also brought a more objective perspective to bear on the evidence because he had not been involved in the investigation. And the next paragraph reads, in finalizing the report and presenting the final report to McBride for authorization, we sought to conduct a thorough, critical and objective review of the totality of the evidence and to present only recommendations that were supported by credible evidence. And then he goes on to contest the views of the minister who criticizes the acts of IPID in regard to the amendments, if they could be called amendments to the first report. Is that consistent with your understanding?
That's correct, Chair.
Just go to 1145 and 1225. You would bear with me, Chair.
Okay.
The first, or the cover page of that affidavit, just for record purposes, is in bundle YC, Exhibit YC at page 1225. Just go to 1145. Also in bundle YC, at page 1145, is Kuba's statement during the course of the Workmen's interview that he held, where he said at line 15, "The issue there was not even a single time where McBride said to me, 'Change the report to suit Ramat.' He might have made inputs, he might have queried how things were done. Sometimes the issue, most especially the issue of having a crime intelligence member, he had a concern about it, to say, 'Are you people not independent?' It seems that what Mr. Kuba is saying there is that you took Kuba to task in relation to the independence of the investigation, and he's also saying that you never told him to change the report to suit Ramat.
That's correct.
Is that correct?
That's correct.
Then in paragraph 43 of your statement, if we can go back to page 9 at last, you say a critique of the Workmen's report was filed with my papers when I challenged my unlawful suspension in the High Court.
One second, Chair.
Paragraph 43, page 9, bundle A.
Are you going back to the statement?
Yes, Chair.
Okay.
Bundle YA, page 9.
Does that mean you are done with the Workmen's report, or you will come
Well,
back
that
to it?
depends on the answer to the next question.
Oh, okay. No, that's fine. Then I will
But
wait.
we may have to go to
Okay. No, that-
beginning page 1017, which is, let's see, still in bundle C. So perhaps if you could keep it at hand, Chair. The affidavit that you prepared for the purposes of the High Court application, which later was dealt with by the Constitutional Court, is Annexure G in bundle YC. And I'm referring to not your founding affidavit for present purposes, but I'm referring to your replying affidavit, because in the answering affidavit, the Minister relied to a large extent on the Workmen's report. So if you could go to page 1007 of bundle YC, please.
I have a check.
Council, please repeat the page number, Mr. Pretorius, on YC, Exhibit YC.
Page 1007.
1007. Thank you.
You have that affidavit before you?
Yes, sir.
To place this replying affidavit in its proper context, it appears that in the answering affidavits in the matter before the High Court where you challenged your suspension, the Minister had relied to some extent on the contents and findings of the Workmen's report.
Yes, that's correct. Yes.
And in reply then you dealt with the Workmen's report.
That's correct.
Now we have dealt at some length with issues related to the Workmen's report and your critique at a high level and at a detailed level with the contents of that report. Perhaps it may be necessary at some stage to do a thorough analysis of the record, because the record is there as it stands. We have been provided by Workmen's with all the transcripts of evidence, save of one person, that is Advocate Mo Singh. Is that correct?
No, that is not correct, Chair. It's Mr. Sissoko's entire interview and transcript has always been absent from the Workmen's report.
All right, sorry, I got that wrong. Yeah. It's Mr. Sissoko's transcript that is not contained, but other than that, we have been provided with the terms of reference, the report, and the transcripts of evidence of all who participated in interviews, save for Mr. Sissoko.
Yeah. In fact, during the litigation period, we relied on Mr. Sissoko's own recording he made, which it was transcribed and authenticated, and we made use of that. But Workmen doesn't refer to it at all, and they don't supply it, even though Mr. Sissoko was interviewed by them.
As a matter of interest, do you know whether there is a reason why transcripts for interviews with other people are available, but the one with him is not available? Or is that something that was not canvassed, they were not asked?
I don't remember it in detail now, Chair, but Mr. Sissoko is very legally minded and very direct. So he would have put legal status of everything immediately on the table. And from memory, he indicated to me, and I might have seen it in a transcript, he inquired to Mr. July as to whether he was a suspect in anything.
Yes.
And Mr. July replied in the negative, which would reflect very poorly on Mr. July, on the fact that Mr. July makes recommendations. Subsequently, at the end of his report, to indicate that Sissoko should be amongst those charged and disciplined. I'm not sure what the ethical aspects of that is, but Sissoko reported that to me.
But you also referred to the use of some recording that Mr. Sissoko himself had made. Was that a mechanical recording or just notes that he took? Do you know? Do you remember?
Yes, I do remember. It was an electronic recording, either on his phone or on a dictaphone or something.
Yes, but you say that was transcribed?
Yes, sir, it was.
Yes. Okay, all right. Thank you.
To get back to your replying affidavit and your critique of the Workmen's report, we have dealt with a number of issues, both in detail as regards to the particular submissions or contents of the interviews, as well as your high-level critique of the fact that there was an investigation by Workmen's at all under the direction of the Minister. Your critique is recorded at page 1017 and following of the replying affidavit. It's a matter of record. Is there anything you wish to add to that?
Chair, I think it's sufficient as it is captured in the affidavit. I'm sure that Mr. Kuba and Mr. Sissoko will give further details which would help the Commission come to its conclusions.
Thank you.
But to put it at its highest, you were critical of the content of the report, the analysis of the evidence, and the outcome of the report. Is that correct?
That's correct, Chair.
Chair, I don't know if you require us to go into further detail on that. It may become relevant later as matters progress, but then we can address it then.
Yes.
But
no,
to go into a page-by-page
Yeah.
analysis of all the evidence,
Yeah.
all the detail, I think would not be productive at this stage.
No, that's fine. Mr. McBride, during your interview with Mr. July, in whatever way or terms you may have put it, did you ever say or ask him something along the lines, what's the whole point about this alteration of the report when there is new evidence? What's the whole point? You know, if it's altered because there's new evidence, what's wrong with that?
I think, Chair, just to respond directly, and from what I can recall, amongst my last statements of the interview, I indicated to him, in an attempt to answer your question, that I stand by the report that I signed. And I also made the point that no court in South Africa will, based on the evidence that I am aware of, will ever be able to convict General Sibiya or Dramat. And I expressed that as the confidence we had in the analysis and the exculpatory evidence, which in April 2015 I was now aware of fully. And I expressed that to him, but it did not resonate at all. With the team who was sitting there, the moment I said, I stand by my report that I signed, everybody started feverishly writing, taking notes. They exchanged glances and started writing, as if somehow I admitted shock and horror, some unspeakable deed. For me, that was an indication of some kind of prior misunderstanding, because for the first time they exchanged glances with each other. When I said, I stand by the report that I signed, and I don't know what they can explain for themselves, but that's what I picked up. And I expressed throughout the interview, subsequently in testimony here also, that it was just crazy from the beginning, the fuss that was made about it. So I have expressed it specifically with Mr. July. I'm not sure if I specifically said it, but I had indicated it, yes.
Did Mr. July or anybody who may have formed part of his team where during your interview with him, did anybody ever say, but the recommendations you people made in the final report are not justified by the evidence that you are relying on, or anything to that effect? Or did they express criticism of the final report based on evidence that was available?
Chair, no, at no stage. At all stages, including in the written report, was just the fact that a report, recommendation and opinion had been changed.
Yes.
No criticism of the final report. And in fact, increasingly, well, it's now common knowledge that all charges against General Sibiya and General Dramat were withdrawn on this matter.
Yes.
So even the NPA, who decided to prosecute us for the recommendation we made in the final report, now has withdrawn charges against General CBA and General Dramat.
Thank you.
If, just for the sake of completeness, we could then go to bundle YD. Sorry. Yes, YD 1443. At page 1443, and subject to any need that might arise for a more in-depth and complete analysis, we can end here to repeat the finding and comment on it at para 645 of the Worksman's report.
Thanks.
Did you say the page is 1443?
Yes, of exhibit YD.
Thank you. Thank you. You may proceed.
Paragraph 6.4.5 is the recommendation that concerns yourself. It reads, in the absence of any information as to which of the three co-signatories were responsible for the deletion of information from the first report, we recommend that Kuba, McBride and Sissoko be charged criminally for defeating the ends of justice or obstructing the administration of justice, and that disciplinary charges be brought against them in their capacity as employees. Just a number of remarks arising from your evidence, and then we'll conclude this part of the evidence, Mr. McBride. It seems that what Worksman's concentrated on was the deletion of portions of the statements quoted in the reports. So not the deletion of the original or any alteration of the original statements which remained intact, but those passages which were quoted in the first report and the second report.
That's correct, Chair.
You've explained to the Chair that an analysis was done, and we've referred to Mr. Kuba's evidence in that regard with the assistance of Mr. Sissoko, because we now know that Mr. Sissoko was assisting for the first time. He'd been excluded in relation to the first report.
Yeah. Chair, I don't mean to be flippant, but I think I need to make a point that even if the second report was completely taken and torn up and thrown into a bin, and only the docket submitted with all the evidence, there'd be nothing unlawful about that. So even if we removed the entire report, did not add a report, and we threw it in the bin, and only sent the docket with all the evidence, there would be nothing unlawful or untoward. SABS detectives do that every day when they submit their dockets to the NPA. They don't attach opinion recommendations.
There are no findings here, it seems, in relation to the necessity for the additional investigative results contained in the second report. It simply seems to concentrate on the deletion of information in the report.
Yeah, that's correct.
What if it is put to you that the deletion of the information was deliberately calculated to mislead the recipient of the report or the second report?
All the evidence is in the docket. None of the quoted statements in the report were designed to mislead or to misdirect anyone. The key element and difference of the two reports, as I indicated earlier, was the conditions in which they were done. It would be thumbsuck to say and there would be no basis on which to say the removal of quotations in a report from a statement, there was anything untoward about it or improper. It's just whoever invented that clearly didn't understand processes that are involved in the situation. And it appears that that misunderstanding, willful or inadvertent, permeates the entire process downstream that eventually led to us getting suspended and criminally charged. And it just seems to have its own infectious nature about that misunderstanding. It appears to be contagious.
It seems then, in summary, what you're saying is that to accord the so-called first report with a quality that it can never be changed or commented on or subject to further investigation is factually and legally incorrect, you say.
That's correct.
Secondly, you say that the assessment which gave rise to the report in its final form, including the decision as what quotes to retain and what quotes to admit from the witness statements, is a matter of judgment by the authors of the second report. And there was nothing untoward in the exercise of that judgment. That's as I understand your evidence.
I'll go further, Chair, and say it's a matter of professional judgment and opinion.
Yes. And that Mr. Kuba makes clear because he consulted with Mr. Sissoko, and they can come and give their evidence about that.
Absolutely. And they have experience in doing this.
Right. Thirdly, you say that had you not done the work in relation to the investigation that resulted in the production of the second report, you would have been acting improperly and unlawfully.
Absolutely.
So, Mr. McBride, as far as you can recall, and I didn't pick this up on the Workmen's report, but you have looked at it much more closely, I think, over some time. As far as you recall, it never addresses the question of saying if the alteration came about as a result of the further investigation that was done, what was wrong with it? Was there anything unlawful about changing it in order to be in line with the later investigation?
No, Chief.
It doesn't address this as far as you recall.
No, Chair, it's completely ignored, that aspect.
You know, it's, well, we will hear other witnesses, but you mustn't feel bad about emphasizing some of the points you have been emphasizing about this report, because if anybody is going to recommend, that people be criminally charged, they really need to apply their minds properly to issues, because people being charged criminally is not a small matter.
Thank you, Chair.
You've already made it clear to the Chair in that regard that as far as IPID is concerned, that although it makes its own comments and gives its own opinion, the duty on the prosecutor to determine the fate of persons, whether they should be charged or not, would be obviously to examine the full contents of the docket, and those were never tampered with.
That's correct, Chair.
Finally, if I could just ask you to look at, and I mean finally for this aspect of the evidence, at page 1152 of bundle YC. You will recall that the attitude of the minister, the attitude of those that took IPID to task, including yourself, was that the first report somehow had a status that could not be tampered with. It appeared that that might have been, well, the motivation of Workmen's in making its recommendations. But would you look at 1152, please?
I have it, Chair.
This is a communication from the Director of Public Prosecution's Gauteng Local Division, Mr. Roberts, SC.
Yes.
It's dated the 23rd of April 2015, almost a year after the second report was filed.
Yes.
And it's addressed to the Acting Executive Director, Independent Police Investigative Directorate.
That's correct, yes.
That would have been who at the time?
It would be Mr. Khamanyani.
And in relation to the rendition cases, are these the same rendition cases or are they different?
It's the same case, Chair.
Right. It says in paragraph 1, the following further investigation must be taken or must be done before a decision can be taken. And then there are a number of subparagraphs which talk about an expert analysis of cell phone data in relation to Major General Sabir, in relation to his alleged presence at the crime scene. It talks about transcript of SMS messages sent or received by Lieutenant Colonel Maluleke, Major General Abia, and Lieutenant General Dramat during the period of the operations. Talks about further cell phone records. And on page 1153 is a long list of other matters to be investigated. The letter concludes at paragraph 2 on page 1154, the matter must be regarded as urgent as the investigation must be completed on or before 12 May 2015. So that it seems, despite everything and despite all the allegations and evidence, including those which led to your suspension and criminal charges being laid against you, that even in 23 April 2015, the investigation was hardly complete.
Chair, there's an additional problem which has only struck me now. A lot of what Advocate Roberts is asking for should have been in the docket then. So, and it was part of the docket. And if from memory, and Mr. Kuba can, at this stage, Mr. Kuba and Mr. Sissoko are not yet suspended. Mr. Angus takes over the case under direction. But it appears that the point you were making, that even then, after I'm gone, they're still looking for additional information. I will agree with that. But it appears that some of the information they're looking for from memory was in the docket. As I look at them, I hadn't looked at them line by line. And these are issues that Mr. Kuba had included. So there's an additional problem in addition to the one which you raised to me, that it was not yet complete after I've been suspended in any case. For the moment, the letter seems to indicate that
further investigations were necessary before a prosecutorial decision could be made, but you add the concern that certain information may have been removed from the docket, but the best person to comment on that would be Mr. Kuba, I presume.
Yes, sir, that's correct.
In paragraph 44, you repeat aspects of your critique in relation to the report, and you then talk about...
Are you back to the statement?
Back to the statement, sorry, paragraph 44 on page 9 of Exhibit YA. You talk about the costs to the state of the whole rendition saga, and you estimate the cost to the state of being in the region of 17 million rand, according to a reply to a parliamentary question put to the Minister in 2017. Is that correct?
That's correct, yes.
You say in paragraph 46 on page 9 that Kuba and Sissoko were suspended by Khamanyani, the then acting director of IPID, on 21 May 2015. You say that that was on the instructions of the minister, is that correct?
Yes, Chair, just to add that Mr. Sissoko, on his suspension and being informed by Mr. Khamanyani, made a recording of Mr. Khamanyani saying that he's been given instructions, which instructions can only come from the minister, to suspend him. So in Sissoko's application or preparation of papers, at the stage when we ran out of funds to challenge the decisions that Khamanyani took, Mr. Sissoko has a recording and a transcript of that conversation with Mr. Khamanyani.
You were suspended for what period of time?
I was suspended from the 24th of March 2015, and I returned to work on the 19th of October 2016. So it's approximately 18 months.
Right. In broad summary, what did you find on your return in relation to issues relating to restructuring, transfers, dismissals, and appointments? Don't go into the detail yet, we're going to go into the detail, but just to introduce this topic in a line or two.
I think just for context and the purpose, I should start by saying that one of the first decisions taken by Mr. Khamanyani was to terminate IPID's brief to lawyers to challenge the minister constitutionally. So immediately that brief was withdrawn.
Is that why you explained that in the Constitutional Court it was only you, prior to that it was IPID?
That's correct.
IPID and you?
Yes, so the issue is, his first decision as Executive Director was to ensure that IPID does not act in the interest of protecting the independence of itself. That's the first decision he took as acting Executive Director. Now, the rest of the stuff was a lot of bizarre transfers, suspensions.
Before you go, you deal with those, Mr. McBride, just to understand, because you did mention earlier also that you and I think Mr. Sissoko ran out of funds at a certain stage. Now, the application that you made to the High Court yourself, and later the matter went to the Constitutional Court, the applicants there were reflected as yourself and IPID, is that right?
In the urgent,
only you?
It was only me, sir.
At the time you went to the Constitutional Court, was it only you?
That's correct.
In regard to that same matter about which you went to the Constitutional Court, were you the only applicant at the High Court level as well?
Yes, I was the only one, and then I was joined by the amicus.
Oh, yeah, except for the amicus, okay. But wasn't there an application that was brought by you and IPID? There was such.
Yes, during the urgent application on 12th of March, 2015.
Okay, but that's how far IPID went.
That's correct, Chair.
So the protection of the independence for IPID that ultimately the Constitutional Court confirmed is effectively protection that was confirmed not just for yourself but also for future executive directors of IPID and for IPID on your own, so to speak, without the institution itself.
Yes.
And,
yes.
And you paid for all of that.
Yes, Chair.
And IPID did not pay.
No, IPID did not pay. And including the labor court aspects, the disciplinary. In the labor court matter, we approached the labor court for an interdict to stay the disciplinary until the Constitutional Court had made its pronouncement on the matter. That also was from my pocket, and the process of the initial disciplinary. So all of that, it
out of your pocket.
Yes, and so the same issue with Mr. Sissoko and Mr. Kuba and their disciplinaries, and they are still in the process of paying back money now.
Yes. In regard to the matter that went up to the Constitutional Court, I would imagine you got reimbursed when a court order was made against the minister?
Yes, there was a reimbursement for that matter, and after taxation, we then received the after taxation, I think is a legal term, subject to taxation. Yes, we did receive it. Now, it would be okay if the matter was left there.
Yes.
But we also had then to utilize money in the criminal case to defend ourselves.
Yes.
Which it's only now that IPID is considering reimbursing Mr. Sissoko and Mr. Kuba. I've never been reimbursed for the criminal case. And that's the, that's the tragedy of all of this.
Okay, thank you.
Mr. McBride, perhaps it needs a slight degree of clarification. The original notice of motion in the application to the High Court concerning your suspension is at page 143 of bundle of Exhibit YA. But let me just put the sequence as I understand it from a review of all the papers. An urgent application was brought in regard to the suspension to which you've referred. In that application, there were two applicants, the Independent Police Investigative Directorate and yourself.
That's correct.
That application had two parts. Part A for interim relief on an urgent basis regarding your suspension. Part B, a declaration of unconstitutionality, and we've been into that detail. Part A, the urgency, the judge found that it was not urgent.
The judge's reasons was that I had not been suspended yet. It was impending. no harm done. One of his reasons.
But anyway, Part A relief was refused.
Yes,
That was the application for urgent relief.
yes.
Quite how it was phrased. It's not necessary to debate that now. Part B then continued later, and at that stage you were the only applicant. Is that correct?
Chair, let me just go back. In Part B, in the judgment of Judge Fabricius, he indicated that Part B, words to the effect, stands a chance, it has merit, and which he said, which he didn't have to say. But he did say it in his judgment in turning down the urgency. So it was identified at first go by Judge Fabricius, even though he turned down the urgency aspect.
But Part B eventually ended up in the High Court.
Yes, that's correct.
And then went on to the Constitutional Court. But when Part B was determined, you were the only applicant.
That's correct.
In regard to Part B, was IPID, or let me first ask, in pursuing Part B, were new papers prepared, or was use made of the papers that had already been filed in the urgent application? Do you remember?
I can't remember
can't
exactly
remember.
now. Yeah.
Okay, but it was one applicant, and that was you leaving out the amicus and so on.
That's correct, because
Okay.
by the 1st of May, by the 1st of April, IPID, if I remember the date correctly, IPID had terminated its brief. So I think we only submitted in August or September the final papers for the High Court
Okay.
of that year.
Okay, thank you.
Again, just to complete that line of questioning, in the original application in which IPID and yourself were applicants, your founding affidavit traverses all the issues that finally came before the Constitutional Court.
That's correct, Chair.
That affidavit is at page 148 of Bundle YA. But let's return to the point which we have arrived at. You say you were suspended for a period of 18 months. You came back and you found that things had changed. And you're now going to tell the chair of how they had changed, particularly in relation to restructuring appointments and dismissals and transfers. Am I correct?
That's correct.
Okay. In your absence, how many senior managers were suspended or transferred? You deal with that in paragraph 47.
It's at least 8
Suspended or
senior
transferred.
managers.
I'm sorry? I interrupted you, I'm sorry.
Chair, yeah, in terms of at least 8 senior managers were affected in one way or another, either by a transfer or a suspension. It might even be more than the 8, because some were transferred mainly to fill gaps that were left at those who were transferred seemingly for what?
You'll come to the detail later,
Yes,
or some detail later.
yes.
Just a question before the long adjournment. Do you recall the analysis that you did together with Messrs. Pillay and Dramat?
That's correct.
The notion that a senior officer bearing some responsibility in a state institution is removed, and that is followed by an overall restructuring and other dismissals and appointments, was that unique to IPID?
No, Chair, we had noticed the same pattern in DPCI, and we had noticed the same pattern in SARS.
Yes. Chair, may we adjourn?
Yes, we'll take the lunch adjournment and we'll resume at 2. We adjourn.